news, I was thrown back to a moment when I had the opportunity to meet her. It was just a few years ago. We were at the Supreme Court that night at a dinner that she was hosting for my colleagues at Columbia. And I ran into her, literally ran into her. And I was so struck by her presence that I really couldn't string two sentences together. Our eyes were both downcast when we met. I said who I was. She said, "Oh, I know you," smiling, shaking my hand. "Yes, I've read your articles." And I'm thinking, she really did say articles, as in more than one. And I was thinking, is this a good thing? I was wondering. She was still smiling, so it seemed to be. And at that point, I'm just really done at that point. Nothing remotely academic or legal or halfway intelligent came to mind for me to say. I was in a fangirling moment. Now, in hindsight, there was so much that I could have said. You know, people who tell you how to talk about small talk say, start with the commonalities. So I could have started with the fact that we both graduated from Cornell. We both matriculated to Harvard Law School. We both found our way against the odds to the faculty at Columbia Law School. We both spent some time at the ACLU Women's Rights Project. And to boot, I'd enjoyed swapping stories with my colleague Jane Ginsburg about growing up with path-breaking, hardworking mothers who didn't cook. So notwithstanding all that, I couldn't come up with anything to say, and I still really don't know what I would have said. What is it about being in the presence of towering change agents like Justice Ginsburg that makes it sometimes difficult to know what to say? And in retrospect, I realized that maybe the question was, do I measure up? Do any of us measure up? And in this current moment of activation, that really is the question for an entire industry of social justice thinkers, activists, advocates, academics, all of those who have inherited the legacy of Ruth Bader Ginsburg and accomplices like Pauli Murray. So I guess the question that really grounds this conversation is, are we up to the challenge of doing more at this moment than passing honorific words over her deeds? Can we carry the great weight of figuring out how to steer our society back from the brink to find a clear pathway to the democracy that we might have had if gender and race barriers that Ruth Bader Ginsburg and so many others had crumbled decades earlier? So her calls for justice were often blunted by a conservative majority, but they ring so excruciatingly true today, especially when it comes to the threats to our democracy. They are so big, these threats, that we might feel small by comparison. But even here, her own modesty in setting forth her epitaph is instructive. She said, "I want to be remembered as someone who used whatever talent she had to do her work to the very best of her ability and to help repair the tears in her society." Well, this evening, I'm joined by some of the leading thinkers in the progressive legal world to mine Ruth Bader Ginsburg's legacy, to interrogate how the courts can serve as a protector of the invidious status quo, which we don't want, and to think about how law can be marshaled to now once again try to serve the historically marginalized. Now, the importance of this discussion was only underscored by that nightmarish presidential debate that we had, in which the President of the United States instructed white supremacists to stand back and stand by on Election Day. Now, that capped a week in which anti-racism has been rolled back by an executive order throughout the federal government and almost any entity that federal dollars reach. Although the world now is aghast at his encouragement of violence, this is only one face of a wider, deeper assault on the civil rights legacies of the last half century, one that has been shaped by and now shapes the makeup of the judiciary. Now, this moment is likely to change the trajectory of civil rights decision-making. But the sea change isn't well understood among those of us who most benefit from jurisprudence set out by Ruth Bader Ginsburg. So it begs the question, what has happened in the popular understanding of the courts that has led to the minimization of those who stand to lose the most with this continuing rightward march to within American constitutional law? And what explains the choices of even our democratic administrations to set aside the contemporary heirs of Thurgood Marshall and Ruth Bader Ginsburg? So these are the topics that we're going to talk about in our 90 minutes together. And we're going to start this evening by hearing from Erwin Chemerinsky, professor of law and dean at Berkeley Law School. He's the author of many books, including We the People, a progressive reading of the Constitution for the 21st century. From there, we'll move into an opening segment with Sherrilyn Ifill, the President, Director Counsel of the NAACP Legal Defense Fund and author of A Perilous Path, Talking Race, Inequality, and the Law. We'll move to Devon Carbado, Professor of Law at UCLA Law School and author of Acting White, Rethinking Race in Post-Racial America. We'll also be joined by my colleague, Cheryl Harris, professor in civil rights and civil liberties at UCLA School of Law and author of the world-renowned article, Whiteness as Property. We'll then hear from Melissa Murray, professor of law at NYU, faculty director of the Birnbaum Women's Leadership Network and author of Law School in a Different Voice. And finally, Suzanne Goldberg. She's Executive Vice President of University Life at Columbia University, founding director of Columbia Law School's Sexuality and Gender Law Clinic, and co-director of Law School Center for Gender and Sexuality. She's a former civil rights litigator at Lambda Legal. Now, throughout this Blacklight event, we want to hear from all of you. Please share your thoughts in the YouTube comments or tweet us at AA Policy Forum. You can expand the conversation across social media by following us on Facebook, Twitter, Instagram, using the hashtag #UnderTheBlacklight. So, Erwin, I'm going to turn first to you. You can only be with us for about 20 minutes. So I want to start by asking you to talk about your favorite quote from the late Justice Ginsburg and provide a little context on why you find that quote or the case particularly resonant.
Thank you so much for having part of this program with this incredibly distinguished group. When you asked me to pick a single quote, I took one from a Supreme Court opinion. It was a dissent by Justice Ginsburg from April 6th of this year. It was a case called Republican National Committee versus Democratic National Committee. Wisconsin was holding its presidential primary and also its primary for state offices on Tuesday, April the 7th. There was an enormous increase in requests for absentee ballots for obvious reasons. So a federal district court said, Wisconsin law would have required the ballots come back to the state to be counted by Tuesday, April 7th. So many people won't have gotten their ballots by then, or if they turned them in, they wouldn't have been returned to the state in time. So the judge said, I'll extend the time for ballots to be received by the state till Monday, April 13th, when they can still be counted. This seemed to me to make so much sense. The Federal Court of Appeals had no problem with it, but the Supreme Court 5-4 reversed. It was split along ideological lines. Roberts, Thomas, Alito, Gorsuch, and Kavanaugh were the majority. And Justice Ginsburg wrote a terrific dissent. I see you put it on the screen. And at the risk of paraphrasing and losing the eloquence, what she said was, we're in the midst of a pandemic. We shouldn't put people to a choice between voting and risking their health. I think this shows Justice Ginsburg in terms of her concern for and awareness for the human consequences of law. I also picked this because we approach November 3rd. There's going to be a need for federal courts to protect the right to vote, especially the right to vote of people of color. And I worry very much what the majority of the court is going to do. And we're not going to have a Justice Ginsburg to write a dissent like this.
And so, Erwin, I think some folks will probably wonder, well, dissent is a dissent. What's really, first of all, the loss of a dissenting voice like Justice Ginsburg? And I think more broadly, what is the role of dissent in the Supreme Court. She's going to be known, has been known as one of the great dissenters. What's great about having someone who articulates the possibilities that could have been?
Many things. First, some voice can persuade a majority of the court. She was born in 1933. She was a Jewish woman who went to law school at a time when women weren't being hired as lawyers. She saw things that none of the other justices had seen, and sometimes that voice can make a difference. But if it doesn't, still having her there as a dissent matters. It matters in terms of resonating with public opinion. The quote you put on the screen was widely publicized in news across the country. Dissents matter in rallying people, and dissents matter for the future. They can be a basis for the court to do something different and better at some later time.
You know, you mentioned just now about the role of the dissent in rallying people with an eye towards a future, with an eye towards an opportunity for decisions, doctrines, ways of thinking about social problems that might not rise to the top at one moment, but because it's part of the conversation, there may be a day for it in the future. And some may say that we're in a moment where the conservatives are realizing that long-term strategy, going all the way back to the moment that the Warren Court transitioned to the Burger Court. And I'm just wondering what we need to understand, or maybe more broadly, what is not understood among those on the liberal side of the aisle, and by that I mean, you know, stakeholders, about the importance of the court, about the long-term strategy to, in some ways, get back into the game. What is it that you think gets in the way of this being the galvanizing issue for progressives and liberals and their constituencies that it seems to be for conservatives and their constituencies?
To begin with, we've got to remember how much the court affects all of us, often in the most intimate and important aspects of our lives. We also should remember that there's rarely been a liberal court in American history. Really, it was only between about 1962 and 1969 that the Warren Court was a liberal court in the way we remember it. So much of that, we've got to remember, was an accident of history. Since 1960, we've had 32 years of Republican presidents and 28 years of Democratic presidents. But Republicans have picked 15 Supreme Court justices. Democrats have picked only 7. That's just the accident when vacancies occurred. So we shouldn't think that the laws that exist now was any way preordained to be that way. It was never meant to be that way. It's just who we've ended up having justices. Had Hillary Clinton won rather than Donald Trump able to replace Scalia and Kennedy and Ginsburg, we would be talking about a very different court for years and decades to come.
You know, last night in that thing that we witnessed, there was a moment when President Trump seemed to taunt former Vice President Biden about the fact that President Obama left dozens and dozens of open seats. And I want to know, first of all, what is he not saying? How is that frame sort of distorting what happened? And then on the other hand, is there anything in that recognition that we as people who are concerned about the direction of the court really have to grapple with when it comes to how much of a priority the courts have been with Democratic administrations in the past?
There was a Republican during the last 2 years, the Obama administration, and the Republican Senate simply wouldn't confirm President Obama's nominees for the federal courts. They wouldn't do it for Chief Judge Merrick Garland. They wouldn't do it for Federal Court of Appeals judges. They wouldn't do it for district court judges. So the reason why those vacancies were left open was a Republican Senate wouldn't be willing to consider and confirm them. Now, there is a lesson there. If the Democrats should win the Senate in November, and if Joe Biden wins, He should do what President Trump has done, appoint and fill every vacancy while he's got the Democratic Senate. You never know when the Democrats will lose the Senate, maybe in 2 years, maybe in 4 years, not to wait. Both President Clinton in his first 2 years and President Obama in his first 2 years didn't make judges the priority that they should have done.
And why not? I mean, that is really the puzzle, right? Because as we're seeing, yes, it was important to get healthcare. Yes, it was important to advance the agenda. But if we don't pay attention to the courts, those agendas are obviously going to be short-lived. So what's behind the asymmetry and why the Republicans really seem to get this court thing and our side maybe not so much?
It's a great question. The Republican base has cared much more about judges than the Democratic base does. In 2016, exit polls showed that the number one reason people gave for voting Trump was the Supreme Court. But for those who voted for Hillary Clinton, the Supreme Court was only number 4 on the list. It's not simply leaving vacancies open. It's also who's picked to be judges. Republican presidents have generally picked from the far right. Democratic presidents have picked much more for the center. I could go through as an example the judges on the Ninth Circuit, and the picks of Republican presidents have been much further to the right than the picks of the Democratic presidents have been from the left. So often they pick moderates. I think it's important that we put pressure on a Democratic president to pick quickly, for the Democratic Senate to confirm quickly, but for that president to very much pick progressives.
So, Erwin, a lot of people don't really understand the relationship between politics and appointments to the courts. And I wonder if you might just take us behind the scene, pull the curtain back a little bit, just tell us about your experience in being vetted for a possible appointment to the courts.
This is something I haven't thought about in a long time, and I don't know if I've ever talked about it publicly. In 1998, I got a call from the White House counsel's office saying I was on the short list to be considered for the Ninth Circuit. And they asked me, would I be interested and did I have any skeletons in my closet that would be an embarrassment? I said, I didn't have any skeletons in my closet. I've lived a very boring, though very blessed and wonderful life. You're not going to want me. I said, I've got a liberal track record on every issue. I write op-eds all the time, law review articles. And he said all the nice things he could say. And for about, a month, every day I got a call from an intern in the White House counsel's office asking me for another law review article, or if there's a text of a speech, tax returns, and the like. And then after about a month, he called me and said, you're too liberal to get confirmed by the Senate. Bill Land Lee had just been rejected to be the Assistant Attorney General for Civil Rights based on his opposition to Prop 209 in California. I had been very outspoken against Prop 209. He said, sorry, we can't go forward with your nomination. I've got to tell you, while I would have very much liked that opportunity, I wasn't the least bit surprised. I knew at that moment in time they weren't going to pick somebody as liberal as me.
Yeah. And I think it's just so important for people to understand both the fact that when we're in a moment like this, where we're debating who's going to take up the mantle, who's going to get appointed, and the argument is, well, we have to take politics out of it. Politics are already in when it comes to who's even seen as eligible. And we're not talking about Republicans who thought you were too liberal. We're talking about Democrats. So what that does to the pool, what that does to advocacy, anyone who has in their possible future the idea of potentially being a judge may think twice about writing articles, may think twice about writing op-eds. And that obviously undermines, in I think a significant way, our democracy. I know you have to go, so let me just ask you my last two questions. Let's say that we are miraculously constituting the Judiciary Committee, and we get a chance to ask the nominee a question. What question would you ask?
Let me start by apologizing for my prior commitment, which I have to go. I wish I could stay and hear everybody tonight. I'd ask the following question. Judge Barrett, You've repeatedly said and written you're an originalist. Can you identify any originalist with your philosophy who has ever supported a constitutional right to abortion, who has ever found protection for gay, lesbian, and bisexual rights and transgender rights under the Constitution?
So I'm hoping the Judiciary Committee is hearing us. They're understanding the significance of that question. And let's go to my final question. So we're going to reconstitute ourselves as a messaging firm. We understand that our colleagues have not yet figured out how to fully engage American voters about the importance of the court. What's the message we need to give them?
I'm so much more comfortable talking about the Supreme Court cases than I am doing the messaging. Others will do this so much better than I am. But I'll go back to a sentence I said to you earlier. We got to remind people that what the Supreme Court does affects all of us, often the most intimate, the most important parts of our lives.
Thank you so much for being with us, Erwin. We really appreciate it. Wish we could turn back the clock and have witnessed a different outcome, but we live to struggle. So thank you so much for being with us. So I'm going to turn it over now to Sherrilyn Ifill, President and Director Counsel of the NAACP Legal Defense Fund. So Sherrilyn, many are remembering Justice Ginsburg's legacy as the feminist equivalent of Thurgood Marshall. So in thinking about her legacy on the court, you said that the Lilly Ledbetter case is one that stands out for you as an example of what difference it makes to have someone on the court with a particular aptitude that comes from being a civil rights litigator. So what briefly was that case, and how did her perspective give a vantage point to address what the other justices didn't seem to see or understand?
Well, first of all, thank you so much for including me. This is an amazing group. It's waking me up because it's late, but it is lovely to just see so many terrific colleagues, and I can't wait to hear more of this conversation. I have talked, Kim, about the fact that, that this is the last civil rights lawyer on the bench and why that matters. And of course, I've talked about this in the context of what it meant to have Thurgood Marshall on the bench. And just because you have it up, I'll just talk about, why I think her dissent in the Lilly Ledbetter case was so important. This is the case involving the woman who brought a claim that she was paid significantly less than her male counterparts for essentially doing the same job. And the Supreme Court essentially said that her claim was time barred. And Justice Ginsburg, in her dissent, talks about why a woman would not know that she was being paid less than her male counterparts. And of course, we all know that Justice Ginsburg was a women's rights lawyer at the ACLU. She well understood what pay discrimination was, but she also understood why women are often on the job, not in a position to learn what their colleagues, their male counterparts, are making. They don't sit in the break room and talk about their salaries with one another, and that employers may actually have an incentive to keep that information secret to prevent precisely the kind of claims that Lilly Ledbetter eventually brought. And Justice Ginsburg ends the dissent by saying, it's now in Congress's court. And indeed, Congress takes it up, and the Lilly Ledbetter Equal Pay Act becomes the first piece of legislation that President Obama signs after he comes into office in 2009. And there's that wonderful photograph. So it's important to me because what she's able to bring to that dissent is what we see persistently Ginsburg doing and what Thurgood Marshall did consistently as well. If you are a civil rights lawyer, as I am, and as our team at the NAACP Legal Defense Fund are, then it's critically important to us always that we prove our case. The inferences never go in our direction. So we actually have to make a record, and we're very, very conscious of that. We just won a critically important voting rights case today, expanding absentee voting opportunity for voters in Alabama that we brought on behalf of Black voters who are particularly susceptible to COVID-19. And in the 197-page opinion that the trial judge writes, you hear all of the facts that we marshaled. And that's what we do because we have to. We can't win any other way. So when you see Justice Ginsburg talking about what really happens, it's bringing a kind of reality to it, but it's also that engagement with facts and the record. We see her do this also in the dissent in the Shelby County versus Holder case. Everyone talks about the famous line from her dissent, which of course, is one for the ages, that getting rid of the preclearance requirement, which required jurisdictions to submit voting changes to a federal authority before they could go into effect, is like getting rid of an umbrella in a storm because you're not getting wet. It's a beautiful line. But the beauty of that dissent for me is the meticulous way that Justice Ginsburg goes through the record. She goes through the history of the Voting Rights Act, the history of each reauthorization of the Voting Rights Act, and then the actual record that Congress was looking at when they reauthorized the Voting Rights Act in 2006 and reauthorized Section 5. She talks about the fact that the Department of Justice between 1982, the prior reauthorization in 2006, had objected and denied changes to voting in the jurisdictions, mostly Southern, but not exclusively, but mostly Southern, covered by Section 5 700 times. And that in most of those instances, a majority of those instances, that denial was accompanied by a finding that these changes were made, the changes that were being proposed were intentionally discriminatory. So she's bringing out the actual record that Congress looked at. And this is vitally important in ways that I think people don't understand. When Marshall left the bench, his former clerk said, he knew how to read a record. For those of us who practice civil rights law, this is very important. And it's not unrelated to the issue of the kinds of people, lawyers that we're putting on the federal bench and their preparedness and experience in being able to grapple with a record and respecting a record that litigators create on the bench. And in this way, she was trailblazing. She created the field of women's rights law. And so in that way, she's very similar to Thurgood Marshall on civil rights writ large, but in also having that experience and perspective that she brought to judicial decision-making that we frankly lack on the court. We've got lots of prosecutors, and we've got Justice Kagan, former prosecutors and Justice Kagan. We don't have any civil rights lawyers left on the bench. And it seems almost like something from the past that we would imagine that a civil rights lawyer even would be on the Supreme Court. I think it's important that we reimagine what the court should really look like.
And so, and I'm so glad you mentioned who is on the court, because I'm sure that has some people scratching their heads. So if we don't have people who were, civil rights lawyers, if we don't have people who are actually practicing, who is on the court? So picking up the taunt that happened last night about all the judges that were appointed, who is now constituting the Supreme Court? Who are these people? How do they get vetted? What is it that people need to know about who has been appointed basically to be the referees in American society?
Well, almost all of the justices on the Supreme Court are former federal appellate judges. And that in and of itself actually winnows quite a bit on multiple matters of diversity. Most of them have backgrounds as former prosecutors, as U.S. attorneys, or in the Justice Department, or in the case of Justice Sotomayor as a district attorney in the Manhattan District Attorney's Office. So that's a very skewed lens for a profession that actually is quite broad. And in fact, when we think about the things that we point to about the American legal system that we think of as being at the highest level and that we try to transport to other countries, they actually don't have anything to do with prosecution. They mostly have to do with the protections that we afford people in criminal defense, right? They have to do with the right to counsel. They have to do with being able to confront, the witnesses who are opposed to you. They have to do with fairness and the jury of your peers. And think about all the lofty things we say about our legal system. Most of them actually sit in the space of matters associated with criminal defense and with civil rights, not at all with prosecution. That's not what we brag about, right? And yet we have essentially turned not only the Supreme Court, but the federal appellate courts over to people whose foundational experience as practicing lawyers is as prosecutors. And this is deeply problematic. So it's not just that it's not civil rights lawyers, it's not criminal defense lawyers as well. And so we have skewed. So when we get decisions from the federal courts, and we're kind of confused about them sometimes because they seem at odds with what we know to be the reality of the way injustice works in the lives of ordinary people, we should remember that the people who are making the assessments actually have not themselves, for the most part, been engaged with the law at that level. And that then makes the record even more important. It makes it more important that those judges have the humility to defer to the presentations that are made of litigators who actually know more, and even of district court judges who actually know more. So I think it's really, even what Erwin just pointed to, the Wisconsin case where the court decided that it was too close to the election and they wouldn't allow the district court's order going forward that would have just extended by a few days the period in which you could get your absentee ballot back in when it could be postmarked. The district court's opinion is detailed in describing what voters in Wisconsin are facing and the challenges they're facing in the COVID-19 pandemic to vote at that period in March. And that's just kind of swept away and ignored by first the circuit court and then by the Supreme Court saying, no, it's too close to the election and we're not going to consider this. And that's the picture that kind of riled me up in March. It's just watching people risking COVID to vote. It was beautiful on one hand that they wanted to vote. On the other hand, it shouldn't have come to this. But once again, Justice Ginsburg, in the piece that Erwin pointed out, was talking again about what these people were actually facing, what was the choice actually facing them. So yes, I worry that on the federal bench writ large, and particularly on the federal appellate bench and on the Supreme Court, we talk about diversity, of course, racial diversity, critically important, gender diversity, critically important, but also the narrowness of the professional background diversity of the lawyers who are becoming federal judges is super alarming.
Yes. Thank you so much for that, Sherrilyn. And, for folks outside of, our profession of law, maybe it's inside pool, but what we're trying to do is shed light on how these decisions actually shape all of our lives. It might seem as though it's far away. It might seem as though, what difference does it make? Well, what we're trying to do is talk about what difference it makes, so that it makes a difference to us when it comes to exercising our right to have a say in those who are entrusted with the responsibility to make the decisions that shape our lives. So thank you so much, Sherrilyn. I really want to lift up the point about what you're saying about prosecutors on the court, the preponderance of them. And it seems to be a perfect opportunity to turn to Devon to talk to us about what is playing out in the court's decisions about criminal procedure. So Devon, what case or quote do you want to hold up as illustrative of some aspect of Justice Ginsburg's jurisprudence?
Well, thanks, Kim. It really is a pleasure to be a part of this conversation with people whose work and scholarship I deeply, deeply value. So I don't have a particularly salient quote, in part because I do want to talk about constitutional criminal procedure. And I think some of the best quotes that Justice Ginsburg has written are probably in the domain of what we typically think of as equality law. So I want to talk about the body of constitutional law that focuses on the constitutional constraints placed on police investigatory practices. That is to say, what does the Constitution say about what police officers can do in our lives? Now, as a matter of text, the Constitution says very little indeed, which is precisely why Supreme Court justices are all the more important. And the particular area of constitutional criminal procedure on which I want to focus is sort of Fourth Amendment law. And some of you I know have heard me speak about Fourth Amendment law on this show before. I'm tempted to quiz you, but Crenshaw won't let me do that. So let me just break it down very quickly and then give you a sense of why Justice Ginsburg's jurisprudential voice, even in the context of dissents, are critically important. So the Fourth Amendment, as many of you know, protects us from unreasonable searches and seizure. So that requires us to ask three big questions. One, if the government does X thing, is X thing a search or a seizure? If X is not a search or seizure, the government gets to do it without any justification. That's A. B, assuming that X is a search or seizure, then the question is, well, is that search or seizure reasonable? If the answer is yes, it's reasonable, the government is all good, and that's the argument that the government is going to make. The third question, assume now that X is an unreasonable search and seizure. Do you necessarily win? The answer might be no, qualified immunity. Or the answer might be no, evidence gets suppressed. So let me give you two cases and then I'll stop. That points to the critical position that Justice Ginsburg has occupied. So one question has to do with what is a search? That's one question that gets asked. And the case that puts this into sharp relief is US versus Drayton. So in this case, 3 police officers get on a bus. One stays at the entrance of the bus and 2 others move to the back to target 2 Black men. They ask, what are you doing? Let me see your ID. Can I search you? Can I search your bag? The question is, are these men seized? Are they free to leave? The court says, yes. They were supposed to just get up, ignore the officers, and carry on about their business. Justice Ginsburg joins the dissent and saying that's madness. No reasonable person would feel free to leave in that context. And in so doing, she highlights the reality of law and policing in people's lives. The other case that I want to focus on is a case called Florida versus JL. So in this particular case, and think about the Amy Cooper, Kristen Cooper scenario as I tell you these facts. Some person calls the police and says that a Black man with a gun is out there. The cops show up, they see 3 Black young men. I mean, they're like teenagers, and they frisk them. And the question is whether or not that frisk is a reasonable seizure based on that anonymous tip. Justice Ginsburg says absolutely no. Whatever reasonable suspicion means, and we know it doesn't mean a lot, we could spend a lot of time thinking about that, it doesn't mean that you get to stop people based on an anonymous tip that is a Black man out there in a plaid shirt. So she pushes back both on what's reasonable as a seizure and what's a seizure to begin with. And both of those moves has profound implications on the conversations we're having about policing and Black lives. Because the narrower the scope of police conduct vis-a-vis what is a seizure, the earlier we say it's a seizure, the greater our freedoms. The more we declare searches and seizures unreasonable, the greater our freedoms. And Justice Ginsburg has been helpful in both of those respects.
So Devon, let me ask you just for kind of a quick riff on what we heard last night. We have been in this conversation in an intense way, since George Floyd was killed, but it's a conversation that many folks have been having for decades. And in particular, I remember actually being somewhat surprised that our effort to say it's not just a bad apple problem was actually turned on its head, and the Vice President Biden sort of went with the bad apple, framework. What are the elements, or what aspects of constitutional criminal procedure sort of debate or discourse actually shift away from the bad apple frame to more robust ways of thinking about what those constitutional rights look like, and where might we put Justice Ginsburg in that shift?
It's a terrific question, and the space to move beyond the bad apple frame in Fourth Amendment jurisprudence is really circumscribed. But here are 2 examples that are efforts on the part of Justice Ginsburg to do precisely that. So in the first case, I mentioned the Drayton case. What the court basically says is the cops weren't acting really, really, really bad. Sure, they went on a bus. Sure, they questioned you. Sure, they asked for permission to search. It's not like they brandished their gun. It's not like they were yelling. It's not like they were saying, get up and listen to us. That's a bad cop. And when we have a bad cop acting out in that way, we'll call it a seizure. So you can see already how the court is looking for a particular manifestation of a bad cop before it calls it a seizure. Another context in which you see this is the exclusionary rule. So the basic idea behind the exclusion rule is this: you violate the Constitution, police officer, the evidence is inadmissible. There are some cases where the stipulation is that there's a constitutional violation, and the evidence don't go out. So here's a category of such cases. Police officer has a warrant. They go search someone's house with a warrant, or they see someone with a warrant. It turns out the warrant is constitutionally infirm. So the argument that the person then makes is, you seized me or searched me based on an unconstitutional warrant. Therefore, the evidence goes out. Classic arguments. In that space, the court has said, no, the fact that it's an unconstitutional warrant doesn't matter unless the cop acted flagrantly. So if you can point to a clerical error, that it wasn't the particular police officer that acted bad, it was some clerk that made a mistake, and so the warrant that should have not been in the system was in the system, then the cop can use the evidence, the prosecutor can use the evidence because the cop wasn't bad. Again, Justice Ginsburg has pushed back against that to raise questions about the structural problem of introducing evidence against a stipulation that what you have is an unconstitutional seizure or an unconstitutional search because the warrant was infirm. The same logic applies to qualified immunity, where the two questions are, did you violate the Constitution? That's not enough. You have to violate a clearly established rule. So it's a really bad cop. It's not just a cop who violates the Constitution. It's a cop who violates the Constitution against the backdrop of a really, really clearly established rule. So again, Justice Ginsburg, in dissent, is pushing back against the way in which this bad apple narrative has found its way into the jurisprudence, which is precisely why we need to pay attention to the relationship between logics that are appearing in these cases and discourses that are traveling in social life.
Yes, yes. And on that note, I'll just put a pin in for a moment. Discourses that travel and discourses that are interrupted or extinguished. So let's just remember that we're in a moment right now when at least anti-racism as a discourse across many different inflections, from implicit bias to critical race theory, is being interrupted by this White House. So we have to pay attention to what flows, what doesn't flow, what makes its way up, and what someone can actually think and believe and still be eligible to be a decision maker, like a member of the Supreme Court. So Cheryl, let me turn to you and ask what case or quote you want to put on the table that amplifies some aspect of Justice Ginsburg's jurisprudence.
Well, thank you, Kim. And I really do appreciate being on the panel with all of my colleagues. I could just listen to everybody and not have to talk, but since I have to sing for my supper, I think I'll try. I want to talk about Gratz versus Michigan. This was the companion case to Grutter versus Bollinger. These were the two cases involving a challenge by disappointed applicants, one to the law school under Grutter and another, Jennifer Gratz, to the undergraduate school at the University of Michigan, both of which the law school and the undergraduate program had affirmative action programs, but they were different. The law school's program took race into account as one factor in what it considered to be holistic review, while the undergraduate program assigned points for various applicant characteristics on a scale of 150. So what happened in the majority opinion, as we well know, 5-4, the court upheld the use of race as a factor in holistic admissions in the law school, but in Gratz, the majority of the court, Justice Ginsburg writing in dissent, the majority of the court rejected the undergraduate points program, applying what it called strict scrutiny to that program and finding it to be unlawful. Justice Ginsburg's dissent in this case is absolutely wonderful. It is one of the most lucid critiques of colorblindness that I think we have actually in modern jurisprudence. And basically what she said is that if we look at this plan, the majority's assumption that race-conscious remedies like affirmative action should be measured by the same yardstick as racial segregation is fundamentally wrong. And you have here up on the screen the point that I would call to here, and particularly this part where she says, to say that 2 centuries of struggle for the most basic of civil rights have been mostly about freedom from racial categorization rather than freedom from racial oppression is to trivialize the lives and deaths of those who have suffered under racism. To pretend that the issue presented in Bakke is the same as the issue in Brown is to pretend that history never happened and that the present doesn't exist. This is a very powerful statement. In reaching that conclusion, she does something that I think I want to harken back to what Sherrilyn was talking about. It's not just that she is objecting on the basis of conceptual grounds. She's basically saying that the court is insisting on the same standard of review for all racial classifications. And she says it would be fitting if in fact the nation were free of the vestiges of rank discrimination. But then she goes on to talk about the empirical evidence that shows that we are not. She points to racial caste in employment. She speaks to unemployment, poverty, access to healthcare, neighborhoods and schools, all of which she say are areas in which race has mattered continues to matter in a very profound way. So her defense of the point system here is not so much a defense of the point system as a rational way of evaluating applicants. I think the basic thrust of the argument is to say the notion that equal treatment, that equally treating race, or that race means the same thing in all circumstances, is ignoring a profoundly important difference. Equal protection does not mean and cannot be defined entirely by equal treatment. Equal protection does not require that we ignore relevant differences. And this is really interesting if you think about her jurisprudence in the context of gender, because I think sometimes people might mistake that as saying that gender is not a relevant difference ever. I don't see her as lacking nuance in either category. What I think she is saying is that there is a formalist logic that is sometimes put forward that ignores the underlying lived experience and facts. And these are relevant to the question of when differences are relevant for the purposes of equal protection, and when under equal protection, certain differences are not relevant or are indeed socially constructed and made up. Even though this opinion garnered only 2 votes, again, I come back to it as one of the most important dissections of the logical flaw of colorblindness. And not to put too fine a point on it, but there have been several sort of fellow travelers, Tim Wise, Claude Steele, and others, who have pointed out that while the critique of the point system was that it was giving a benefit to Blacks and Latinos, that is, it was a preferential treatment of Blacks and Latinos by awarding 20 points for race for being a member of a group that had experienced racial discrimination. In fact, the question may be whether or not there were too few points being assigned for that when one considers the backdrop against which there were points assigned for people who were residents of the Upper Peninsula of Michigan. We can guess which racial group that benefits. Or the 4 points to children of alumni. We can think about who that might benefit. Or the 10 points for students who went to the state's top schools. Or the 8 points for those who took a full slate of advanced placement courses. If we start to add up the number of points that were overwhelmingly going to favor white applicants, the question on the table is not whether 20 points was too much, but whether or not it was too few. Again, the point is not whether or not the point system per se is the right way to evaluate these social realities. The question is, are we going to ever acknowledge that the existing baseline is itself fundamentally asymmetrical? It is not a case of taking race into account against a backdrop of a neutral ground. The ground is not at all neutral. And I think that the brilliance of Ginsburg's dissent here is that she acknowledges and recognizes that.
Yeah, absolutely. Yeah, and fundamental to the critique that you're elevating, that Justice Ginsburg pointed out, is the way that advantage and disadvantage is baked in. It's cooked in. It's in the baseline. Now, some would call that white privilege. And others would say this is precisely the kind of conversation that we cannot have anymore, right? So in a very significant way, Justice Ginsburg dissent is precisely that kind of un-American conversation that our existing president would say cannot be taught. So maybe we can't even teach Justice Ginsburg's a dissent in any federal program. But while I have you on this, I want to see if we can just squeeze in, if we can really squeeze in a little bit of how that sentiment, that to talk about how racial advantages are embedded in systems that distribute opportunity, like admissions or like a test to determine who gets to be a firefighter. To actually acknowledge that and try to interrupt it and make for more equitable measurements is itself discriminatory. So Justice Ginsburg had a long dissent about that. We don't have a long time to talk about it, but can you just hit just the high point about what she had to say about that seems to be so salient right now?
I'll do my best. So I take it you're referring to her dissent in Ricci versus New Haven. And this is a case in which disappointed white applicants for promotion in the New Haven Fire Department claimed that they had been discriminated against when the city of New Haven canceled the results of the selection process that had relied on a test that was weighted 60%, was a written test, and it had unfairly and unnecessarily excluded qualified Black and Latino applicants. So the city, in order to avoid liability for a disparate, what's called a disparate impact claim, that's where you use a neutral criteria, but it has a disparate effect. The city said, forget about this test, let's start over. Let's start with a clean slate, let's get a better mechanism for evaluation. Well, the plaintiffs, the white plaintiffs said, oh, no, 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 no. If you get rid of the test, you're discriminating against us. Well, the majority agreed with the plaintiff's claim, essentially that the ordinary application of anti-discrimination law amounted to an injury to whites. That is, the application of disparate impact law, which has been on the books since Griggs, over 40 years, the application of that law actually was a preference for minorities and a discriminatory act against whites. So RBG's dissent here really dissected the illogic of this position. She pointed out it was a deviation from precedent, but more importantly, she identified the longstanding history of exclusion of Blacks and Latinos from the New Haven Fire Department and the decades of litigation that tried to address it, and basically was saying that the notion that disparate impact law itself can amount to some kind of cognizable claim on the part of whites is tied in, I think, to, again, this critique of colorblindness that she's making in Gratz. That is to say, the presumption is that unless the system favors whites, it is somehow, in fact, discriminating against them. And in that regard, what we have is the selection process being attacked as discrimination is really equivalent, it is tied in very much with what you pointed out at the beginning, the executive order sort of stating that to critique the existing regime as disfavoring racially subordinated groups and favoring whites is itself an injury. To even just state that is itself some kind of cognizable injury. And it's why, for example, the Ricci case was called by many of the conservative columnists and writers at the time as the civil rights lawsuit of its time. He was upheld as the sort of icon of civil rights litigation because he was attacking anti-discrimination law.
Yep.
As being unfavorable to whites. And I want to just say one thing. The case was constantly described as a case about affirmative action.
Yes.
It was not a case about affirmative action. It was a case about ordinary Title VII anti-discrimination law, meaning how do you prove a case when you have a neutral criteria that is unfairly excluding people of different groups?
And one of the things that we know is that ideas that are expressed in the context of legal cases don't end when the court makes a decision. They actually go on and live. So the idea that just the basic operation of anti-discrimination law is effectively reverse discrimination, largely against white men, is an idea that is now underscoring so much of what we're seeing now, including the executive order. So an exceptional and extraordinary, sort of standing to complain, exceptional decisions that create new injuries. We see it in voting rights, for example, constitutional voting rights, Shaw versus Ringo. It creates a whole new injury that basically white plaintiffs get to complain about. And Black plaintiffs never got a chance to complain about those things. So this asymmetry in what is an injury and what the law facilitates and what it prohibits is part of how privilege is being baked into this jurisprudence. And it's one of the things that Justice Ginsburg's jurisprudence helped us see and fight against. So thank you for that, Cheryl. Quickly, social media check-in. We've been on a roll, Owoye, so we're just getting around to you. So I know there's a lot to report that people are talking about, but just give us a little snapshot of what is resonating with our listeners.
Yes. Hi, Kim. As you can imagine, there is a vigorous and dynamic conversation happening this evening. And thank you so much to everybody who's online for all your thoughts and your comments tonight. There's a lot of conversation and reckoning and some horror about the number of federal judges appointed by Trump and the declaration yesterday about the number of judicial vacancies that have been filled. People are really wrapping their minds around the ideas that the courts have been packed by the conservative judges, as you've all been discussing, and what this means for the conservatives to rule in perpetuity. A comment that someone made that a lot of people were echoing was that the Supreme Court messaging should be, quote, a court that affects all should reflect all, unquote. And people talking about how the diversity of the court should reflect the people. And it's all just naturally brought up a number of questions like, how do we fix the imbalance on the court? What do people think of this idea of packing the courts? And what does it mean to pursue our rights through the courts and other institutions that are controlled by conservatives? So lots of wonderful thoughts and a lot of deep appreciation for the incredible panelists tonight. So thank you.
Wonderful. Thank you, Owoye. Thank you, everybody, for your attentiveness. We know we can be in the weeds a little bit because we're talking to each other, but we're trying to open it up so that it becomes clear how important the court is. I love the idea that the court has to reflect all of us. So you raised the bar for our panelists to talk about some kind of statement, bumper sticker, idea that communicates to the entire community how important this matter is. So I'm going to go back to our conversation by turning to Melissa Murray, professor of law at NYU. So Melissa, of course, it's widely acknowledged when we talk about challenges based on sex that Justice Ginsburg's name is right there. In fact, dictionary based on sex is probably one day going to be Justice Ginsburg's name. So what case or quote do you want to bring into the conversation that amplifies her legacy in this respect?
Sure. First of all, thanks for having me. This has been a really fantastic conversation with so many luminaries. I'm really pleased to be a part of it. The case that I want to highlight is one that Ginsburg did not litigate, but rather filed an amicus brief, a friend of the court brief, in this appeal to the Supreme Court. It was in a case called Coker versus Georgia, which was a challenge to Georgia's death penalty for the rape of an adult woman. The case came before the Supreme Court in the 1970s. This was around the time where the court heard a number of different challenges to the death penalty. But this one is really different because the question was about the penalty being used in the context of rape. And in her brief to the court, Justice Ginsburg really highlighted the gendered aspects of using the death penalty as a penalty for the crime of rape. She argued that it really served to highlight the degree to which women were seen historically as the property of men, either their husbands or their father. To punish someone with death for taking someone else's property, not only use death in a way that was perhaps inconsistent with the ways we might think about it today, but again, in a way that devalued the inherent humanity of women and really tethered them to men and understood them in the context of men. But she didn't stop there and just highlighting that sort of gendered frame by which we might understand rape and the idea of rape as a kind of property crime against men. She also considered the way in which the use of the death penalty, particularly in the South, particularly in the context of African-American men accused of raping white women, had really racialized origins and context. And so she argued that not only was there this gender history, there was also a way in which the death penalty served to be used as a means of policing the sexuality of Black men. And more importantly, she contrasted this with the state's indifference to the sexuality of Black women when they were the victims of sexual assault. So it was a really important brief, not one that I think gets a lot of attention. I know that there's been a lot of discussion on Twitter in the days since her death, arguing that although she was very much an ardent feminist, she was not really someone whose jurisprudence had an impact on the lives of Black women. And I think this brief is a rejoinder to that position. And surely her jurisprudence more generally is a rejoinder to that. One of the things that she really worked hard at in her career was dismantling sex stereotypes that posited women as dependents and homemakers and caregivers and men as breadwinners. And surely dismantling those stereotypes had benefits for white women, but they also really benefited Black women because we have never fit comfortably into this ideal of true womanhood, the caretaker, the homemaker. We have always worked. We have often been the breadwinners for our family. So any jurisprudence that focuses on dismantling sex stereotypes redounds to the benefit of Black women. And she also addressed this in her litigation strategy. There's a 1973 case, Cox versus Stanton, in which she sued the state of North Carolina for sterilizing without consent a young African-American woman who, as a condition of continuing to receive public benefits for her family, she was sterilized. She was told that the sterilization would be reversible, and she never learned that it was not until she was engaged to be married and she went to a gynecologist to find out about becoming pregnant and was told that she never would become pregnant. It had a tragic impact on her life. Her fiance left her. She later tried to adopt a boy, and she wasn't able to because she was unmarried. And this was, her life was utterly ruined because of the state's imposition. So it shows a lot of different things. One, that women's reproductive lives and reproductive rights are not exhausted by the question of abortion, but also that this was a particular kind of reproductive injustice that was borne disproportionately by women of color.
Thank you so much for raising, some of this early work on showing how anti-stereotyping does impact, does bring women of color into the mix, even though there might not be a name for it at that moment. The idea, or at least the name intersectional feminism, wasn't obviously articulated then. But there are elements of her jurisprudence, her thinking, that were actually shaped in conversation and partnership with Polly Murray, for example. So in having a sober reflection on Justice Ginsburg, what are some of the things that we have to keep our focus on? Being historical and bringing forward certain elements that might, in this moment, be hard for people to remember when they're trying to evaluate her legacy.
So we have been raised, thanks to you, Kim, on a steady diet of thinking about feminism in intersectional terms. But when Justice Ginsburg was litigating these cases in the 1970s, there wasn't really a vernacular for it. So we didn't have the term intersectionality and wouldn't have it until the 1980s. But I think what you could call intersectionality sort of shot through her thinking and certainly her advocacy as a litigator. She, as you say, she really drew on the work of Pauli Murray. Pauli Murray was an African-American woman. She's also a queer woman. And she's probably one of the most undersung heroes of the civil rights movement. She really was the architect of a strategy of slowly chipping away at what she called Jane Crow. And she argued that Jane Crow was as pervasive and as insidious as Jim Crow, only it worked to sort of keep women in these cages, but those cages were as crippling as laws that segregated the races. And so she already began articulating and developing a theory for combating gender discrimination and sex-based discrimination when Ginsburg came along. And to her credit, Ginsburg always acknowledged the debt that she owed Pauli Murray and other feminists who had come before her. She credits Pauli Murray in her grandmother brief in Reed versus Reed, which is the first brief that she filed on behalf of the ACLU's Women's Rights Project in a Supreme Court litigation. This was a challenge to Idaho's law that prohibited women from serving as executors of estates. And so she was very clear about that. And she talked about the role that Pauli Murray's advocacy played. Pauli Murray was also referenced in Frontiero versus Richardson in her work there, which is her first argument before the Supreme Court in 1973, when she took up the challenge of that servicewoman who argued that even though she had a husband, she should not have to show that he was dependent on her for more than 50% of his living in order for her to receive the kinds of benefits that male personnel received as a matter of course for their spousal dependents.
Yeah. And, you know, I think we can't talk about Pauli Murray too much. And I just do want to underscore that not only did Justice Ginsburg acknowledge Pauli Murray, there are ways in which one could say she's more central to our understanding of gender jurisprudence than she is in our understanding of race jurisprudence. It was her memo that was a foundational piece of the strategy in Brown versus Board of Education. And she seldom gets credit for that. This is a Black woman who is in both race and gender foundational legal strategy making, and still hasn't really gotten the attention that she deserves. So thank you so much for bringing her into this conversation. Suzanne, I want to turn to you. Certainly, last but not least, what case or quote do you want to bring into the conversation to amplify what was unique about Justice Ginsburg's jurisprudence?
So first, I have to thank you for thank you for organizing us, for bringing us together for this conversation. And just have to say, I feel like I'm on a panel of rock stars. So this is really fun and great to hear everybody. So I want to talk about Justice Ginsburg's work on sterilization by government and the consequences of that discrimination. I'll focus specifically on sex discrimination, but her work, as others have talked about, crosses many aspects of identity. And what I'm going to say builds on certainly what Melissa just said, as well as other colleagues. So I want to turn to one immigration case. It's from June 2017 as a window onto how Justice Ginsburg broke down sex stereotypes in the law and showed why they cause harm. This is the most recent, and it might actually be the final sex discrimination case under the Equal Protection Clause that involves women's rights and not focused on LGBT rights. So we will see. The case is called Sessions versus Morales-Santana. It's about an immigration law that made it easier for US citizen mothers than US citizen fathers to pass their citizenship onto their children who are born outside of the United States when the other parent is not a US citizen. So that's a mouthful, but the idea is a US citizen mother and a non-citizen father have a child outside of the United States. The mother could have lived in the United States for a year before the child's birth and then pass on US citizenship to her child, while a father would have had to live in the United States for 10 years or then 5 years before the child's birth. So the legal question in the case was, can the government treat mothers differently from fathers for immigration purposes? And you might wonder, well, what was the government thinking in enacting this sort of different treatment? So in 1940 hearings on the law, the government expressed a concern that the foreign-born child would need a close influence from the American parent, or else they would turn out to be, quote, more alien than American in character. And so Justice Ginsburg did with this dividing line what she did with so many others. She took a sharp look and asked, well, if that's your goal, why have different rules for men than for women? And so she explained that the mother-father law was developed at a time when, and I'm quoting here, when two habitual but now untenable assumptions pervaded our law in this area. In marriage, the husband is dominant, wife subordinate, unwed mother, and second, the unwed mother is the natural and sole guardian of a non-marital child. So in the case, she did three important things that I want to bring into the mix of our conversation. First, she wrote that it is stunningly anachronistic, quote, stunningly anachronistic for the government to treat unmarried fathers as less qualified and less able than mothers to take responsibility for their children. And I actually wrote a brief on that point, I should note, on behalf of a number of population and family law specialists documenting the social science showing that, in fact, unwed fathers don't walk away from their children the vast majority of the time. And so she got the social science, she actually cited the brief, but most importantly, she got that this is stunningly anachronistic. Second, she recognized the on-the-ground consequences of putting this kind of stereotype into the law. And here she says, such laws may disserve men who exercise responsibility for raising their children, making the point that men may, when treated like this by the law, treated as not taking responsibility for their kids, will take in that message and may risk in this setting and other settings walking away. And then she made her classic move, which I think of as intersectional in her own way, although not in the way that you have taught us and broadened the conversation, but intersectional across fields. So she showed us how so many these kinds of assumptions about the roles of men and women intersect with many different fields and areas of law. That is, she didn't just see this as an immigration problem, but she pulled in cases, some of which Melissa referred to, dating back to 1971, in which the court rejected sex-based rules in employment, in military benefits, in the administration of estates after somebody has died, in school admissions, in jury service. And then she looked back and pointed to earlier cases where, for example, women were not allowed to get a bartender license unless their husband or their father owned the bar. And so she really brings together all of these pieces that many colleagues have talked about, looking directly at the law, seeing the dividing line that the law creates, and then putting a microscope on it or a magnifying glass on it and asking us to really think about why is that, and showing us that the underbelly of all of this are these outdated, anachronistic, and deeply harmful assumptions about the differences between people.
Yeah. And, you know, so much of how people think about stereotypes now is limited. It's sort of simplistic. And we see in Justice Ginsburg's jurisprudence the critique of stereotypes as they relate to disempowerment. Now, I'm really interested now because we've been talking, sort of our sidebar has been on the executive order that just came down. It's called an order against race and gender stereotypes. So people might look at that and say, oh, this order is advancing Justice Ginsburg's jurisprudence, kind of like the anti-affirmative action efforts in Michigan and in California called themselves the civil rights or equal treatment. A lot of people were confused about it. So what is most distinct about how Justice Ginsburg thought about and critiqued stereotypes and how President Trump is thinking about stereotypes?
Let's just say they are using the same word to mean different things. And what we see in this executive order, which is really quite stunning, and I do encourage everybody to take a close look at it, is the entrenchment of stereotypes the entrenchment, not only of stereotypes, but really of deep animus, hostility, along racial lines, along sex-based lines, along LGBT sexual orientation and gender identity lines, as a way to say, we're going to take the law and take this idea of equality and turn it on its head. I litigated a long time ago a case called Romer versus Evans, which was about a Colorado amendment that made it much harder for lesbians, gay men, and bisexual people to get legal protections from the state of Colorado and the local governments. And in that case, the promoters of that law, the advocates of that voter initiative, held up, their banner really was no special rights, as though anti-discrimination laws provide some sort of special rights. And in that case, of an opinion in which Justice Ginsburg participated in striking down that amendment, the court said, civil rights laws are not special rights, right? They are laws that enable people to access basic protection, to enable full participation in our society. And the idea of special rights is really, as the court recognized there, and as we're seeing turn on its head today, the idea of special rights is a way to really, I guess the easiest way to say it is to just foster an incredible amount of confusion in a society that hasn't had the benefit of basic civics education to understand that basic rights are the things that we all need in order to have access to government, schools, courts, and so forth.
Right. And when those basic things are maldistributed, when everybody doesn't have it, having targeted efforts to bring those up to the baseline who don't have it in the first place is not preferential treatment. It's not special rights. It is equal rights. Sometimes to do equality, you have to treat people differently. You can be as discriminatory by treating people who are not the same as though they are, as you can be discriminatory treating people who are the same as though they were different. Just sort of a basic point of equality law. So thank you all for bringing to the table some aspect of Justice Ginsburg's jurisprudence. And so we have probably about 10 more minutes to do some rapid fire responses. So by rapid fire, I mean, let's shoot for 30 seconds or so of quick thoughts about things, right? So I'm going to just go through them, and whoever has something that they want to offer, let's jump in it. So we can't not acknowledge one of the critiques. So when all of Justice Ginsburg's clerks gathered to receive her body at the Capitol, folks noticed that there weren't many dark faces. And in fact, in looking, it seems as though perhaps one of her clerks was African-American. What should we think about this? Who has something quickly to say about that?
I'll say something. So I think it's true. She did have one African-American clerk. He's now a judge on the Ninth Circuit, Paul Watford. It's an appalling record. I mean, there's no other way to say it, and it's legitimate, I think, to criticize her for it. I also think, though, that in criticizing her, we sort of make it a kind of individual choice problem, when in fact, it's actually more of a systemic and institutional problem that is not just particular to her, but is also something that other judges throughout the federal judiciary have issues with. It's an issue at law school. We have difficulty fueling the pipeline of clerks with students of color, and we don't do a very good job of actually advocating for them in the way that we should in order to make them plausible candidates. So I think this is a broader problem than just Justice Ginsburg, but I think we should use this particularly glaring account of it to call it to attention and do something to work on it.
Yeah, I would have to agree with Melissa and would say it's very much connected with what I said at the outset. There is a part of the profession that has been reserved in particularly elite ways, and that actually fails to actually reach out to and include all of the people who ought to be part of this aspect of the profession. And the Supreme Court is part of it. Thurgood Marshall had some Black clerks, but not as many as one might think, given his knowledge of race and racial discrimination. Supreme Court clerkships are the elite of the elite. And, there is a systemic problem in our profession with the gatekeeping of what constitutes what is elite. And I think this is a great opportunity to interrogate that. As Melissa pointed out, individual judges, women judges, judges of color can also be folded into that system and be either unable or insufficiently attentive to breaking through. So this is an opportunity for us to do some real systemic work around the whole ecosystem around the Supreme Court. That's why I'm talking also about the federal circuit courts and the district courts. It's not just about the Supreme Court itself. It's an ecosystem that has to be addressed.
So you mentioned Thurgood Marshall. So let's go to this question. So have we learned the lesson after Thurgood Marshall became replaced by Clarence Thomas, when effectively Thurgood Marshall basically tried to give us a warning? What was it, a black snake, a white snake? They'll all bite you. The question is who they are, not what color they are. One can say that if that was like a message, many folk like us, not us in particular, but many folks didn't really get that memo. So are we at a different point now, or is this being rehearsed? It's clear that the current nominee was chosen because she was a woman. There's not a lot of apparently complaint about that from the side of the aisle that doesn't like identity politics playing out. Seems like if the identity politics serves a broader ideological goal, it seems to be okay. But are we getting any hint that this idea of appointing a woman is working to suppress or quell some of what might otherwise be opposition from those who are looking for a pro-woman or feminist person? So is this Clarence Thomas rehearsed, or is it a new day?
Kim, can I just give
I'm sorry, go ahead.
Just because of Marshall and Thomas, I just want to give a historical note, and then I'm happy to kind of sit back and have others talk about Amy Coney Barrett. Because I actually regard the Thomas hearing and nomination and confirmation ultimately as what kind of freed us from what I think before that had been kind of an understanding that there would not be this kind of public rejection at that point of a Black nominee. Now, you know that there are many Black organizations and individuals who supported Clarence Thomas's confirmation to the court. I happened to be a young lawyer at the Legal Defense Fund, organization I now lead, when Thomas was nominated. And obviously we were in a very sensitive position because he was going to be replacing Thurgood Marshall. And we did what we do with Supreme Court nominees, which is that we did a deep dive into his record. We read every single thing he ever wrote. We read every speech. We read every decision. We reviewed his record. We issued a decision, and we opposed his confirmation on his record. We were one of the few civil rights groups that opposed his confirmation. This is even before the Anita Hill allegations came out, purely on his record and on what we thought would be his position and stance on civil rights issues. And I call it freeing because, you know how contentious that was and how much even conflict there was within the Black community. But after that, it freed us. It helped us understand that we don't have to hold back from critiquing someone whose record demonstrates their stance and opposition to core civil rights values because they're Black. And so I think that is the setup for what we are facing today, in which I think people who feel reticent about criticizing Amy Coney Barrett because she's a woman already would have been accepting her underlying views and philosophy. But I think people who don't accept her views and philosophy and stand in opposition to it will not be cowed by the fact that she is a woman and feel that they can't speak honestly about her record or what she's likely to do.
Okay. I appreciate Sherrilyn's observation on this, and I really totally agree. But I guess I do see it not so much as us having not been freed, but as some of us not being yet willing to set down our chains. And what I mean by that is that it still seems to be difficult within some aspects of liberal commentary and discourse to critique somebody on the basis of their political views because of the underlying, I guess I would say, premise that to critique, the underlying premise that law is somehow distinct from politics. And therefore, to critique somebody on the basis of their political view is to be injecting a kind of partiality into an institution that should be impartial and should not be making judgments on the basis of the particular political commitments of the judges. And because of the buying into that principle, the liberal reticence to critique somebody based upon their views, I think is still there, even though I think we could imagine that under certain circumstances, that is legitimate circumstances where this candidacy might be subject to the kind of scrutiny that it ought to be subjected to, we could have a very robust argument about her particular political views. But I still find it to be the case that it rubs up against an underlying reticence to embrace the notion or to resist the notion that the liberal position often accepts the notion that the law stands outside of politics. Mm-hmm. And therefore it disables people from marshaling the kind of full-throated critique that the right is fully willing to wage for the reasons that we just talked about when Erwin began to say he was too liberal to be considered. Here's a man who's a giant of constitutional law and writing, certainly on the basis of his criteria. There should at least have been an opportunity for him to get to a hearing, but he gets screened out at the front end because of the assumption that his politics are too visible. Well, you just put up a picture of Kavanaugh in front of the Federalist Society. The Federalist Society has vetted all of these candidates that we're talking about. None of that is considered disqualifying, but it's only disqualifying when it comes to progressives. So I guess I totally agree with you, but I say that we are not yet ready to put down, some of us, to put down our chains.
Yes, yes. Suzanne, you wanted to jump in on this?
Agree with what you both said. And I think I would just add two things. One, this is another, we talked before about the misuse of ideas of special rights and civil rights. I think this is another place where we see the misuse of the idea of diversity, as though it's a feature that women can have diverse views about the rights of women or the rights of human beings in general. And so that gets played up as that those who oppose a nomination like this want to demand a kind of ideological purity on the part of all women, which is, of course, not at all the issue here. Mm-hmm. The second is that I think, we and I think we need to give our many people, I guess, the capacity to hold two ideas at once, right? One is the idea that we do think or many of us at least think it's important. I think it's important that there be women on the Supreme Court, and that that this is an appropriate seat to have filled by a woman. And at the same time, to say that this particular person, looking at the person, at their views, at her record, as Sherrilyn just said, is somebody who we can critique. We can be supportive of having a woman. We can be supportive of having more people of color on the court. We can be supportive of having people with physical disabilities on the court, and not have to say that every person who has that identity or has that kind of appearance is a person who then gets a pass on examination of their record.
Absolutely. Well, we almost did okay on the 30-second thing. Let me just ask this last thing. If anybody has a burning question that you would like to see, or if you were on the Judiciary Committee, you would ask the nominee.
Well, you actually teed it up to some extent, Kim, which is, I'd like to ask Professor Barrett, what is the role of gender in her appointment? And does the fact that the president stated that he was considering only female candidates, that is clearly that gender was a factor, a critical factor in the selection, does it undermine the legitimacy of her appointment as one based on merit?
Yes, yes. And in the hashtag bumper sticker messaging to our constituency why the court matters. What do we want to leave people with?
Whose court? What courts?
What did you say, Devon?
Whose court? Our court.
Our courts. Yes. And Suzanne?
So this isn't a hashtag exactly, but it's a visual. I think sometimes people vote all the time. People get the idea of judging. There are a lot of likes, a lot of not likes. And I think what I would like to do is take a big pile of those likes and not likes and all the emojis and have them on a scale of justice, but then show that actually what the justices do is they move the scale around. And so it's important to weigh in, but it is also important to recognize that the Supreme Court wields a special kind of power that is much different from the kind of up and down vote that many of us engage in every day on many different kinds of issues.
Absolutely brilliant. Well, so we've come to the end. I first of all can't thank you all enough. Very, very special thank you to my brilliant colleagues and panelists, Erwin Chemerinsky, Sherrilyn Ifill, Devon Carbado, Cheryl Harris, Melissa Murray, and Suzanne Goldberg. How lucky I am that in one way or the other, I'm colleagues with all of them. So thank you so much for sharing this 90 minutes with everyone. This would not have been possible without the amazing team at the African American Policy Forum and the Center for Intersectionality and Social Policy Studies. So thank you all behind the scenes. To everyone else, this has been an inspiring and very necessary conversation. I'd like to encourage you all to keep listening, keep having these conversations with your friends and your families and within your communities, especially over the next several weeks. This could not be a more important time in the future of our democracy. If we can help with providing these materials, please continue to follow us on Twitter and Instagram. We are AA Policy Forum. Follow along here for updates and political commentary that you won't find anywhere else. And check out aapf.org for more information and resources. This conversation will appear next week on the podcast Intersectionality Matters. It's available anywhere iTunes, Spotify, or SoundCloud can be found. We'll be posting this and other conversations as well. And Under the Blacklight will continue next Thursday with a special episode after the vice presidential debate. It features Alicia Garza, Barbara Arnwine, Kirsten West-Savali, and many others. We'll be gathering for lunch or morning coffee. If you're on Pacific time, it'll be Thursday, October 8th at noon Eastern. Watch the debate, watch the network news, see what they have to say about it, and then come prepared to elevate or castigate, as the case may be. We're looking forward to a historical conversation. So if you're inspired by what you heard and want to partner with us to sustain vital conversations in difficult times, check out the African American Policy Forum donate page, or write us at info@aapf.org if you're inspired to do more. Thank you all. Enjoy your evening. And most importantly, make a plan to vote. Like now, like right now. As soon as you log off, get your plan together and let somebody know. All right. For AAPF, I'm Kimberle Crenshaw. Thanks for joining us. Good night, everybody.
Forget the bull in the china shop. There's a China doll in the bullpen. Walk with the switch, fire in the fist, fighting at the bit, swinging every pitch. Coach put me in like forget the bull in the china shop. There's a China doll in the bullpen. It's all in the wrist, fire from the hip, talk a little shit, roll, take hope. Let's begin like it's been assumed I'm soft or irrelevant because I refuse to downplay my intelligence. But in the room of thugs and rap veterans, why am I the only one who's acting like a gentleman?